Good afternoon, all. This hearing is in the matter of CA 004-2024 and is being held by way of video conference before Chief Justice Tun Zaki Azmi, His Excellency Justice Shamlan Al Sawalehi, and Justice Lord Angus Glennie, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the Registry in Dubai on the judge's instructions. The appellants are Mr. Shaun Gregory Morgan, who is self-represented, and Franklin Morgan Legal Advisory, which is represented by Mr. Ubaid bin Tuq Al-Marri. Thank you.
Yes, Mr. Obaid. Mr. Obaid. Obaid?
Yes.
Yeah.
Yes.
I hear you. How do you want to start this hearing? This application? How are you going
Yes.
to start it?
We file appeal on the decision being made on removing the company and giving us a fine, and we had done no mistake from our side. We got to know about a comments by the registrar about the requirement of additional documentation from Shaun Morgan, and accordingly we got to know that immediately the company being removed from the registrar and the company and him, and we got to know all the company and the legal counsel and DIFC court got to know about the action being made. We was looking to understand what the requirement, what the comments from our side, and we approach the chief of registrar about the matter. And on the same time, after I finished the call with Amna Al-Uwais, we got the notification about the filing of the case from the registrar. The company is registered in Abu Dhabi as a legal advisory, and we have no submission from our side on the court. All what is being done was directly from our client, which we assisting them for filing.
Okay.
We got the comment about the additional requirement of some verification related to the documentation of Shaun Morgan, and immediately we do not had any filing or any process so far, and we was waiting to understand what the comments and what the additional requirement by the registrar to be able to complete, or we file also for additional counsel to be added as part 1 and part 2 for the company, which we never been allowed to register anybody.
Mr. Obaid,
Yes.
this is the DIFC courts.
Yes.
Have you appeared in the DIFC courts before?
Myself?
Have you appeared before the DIFC courts?
Yes.
Mr. Obaid?
Yes.
Are you familiar with the rules of the DIFC courts?
Yes.
Have you read the rules of the Dubai courts, the RDC?
Yes.
So why are you saying all this to us? Because it looks as if you are not familiar with the rules. That's why you're submitting as if you are in the Dubai courts. This is not the Dubai court. This is the DIFC court. We follow the English system of common law. When a case is fixed to go on, it will go on. Not like the Dubai court. It's not the civil court. Mr. Shaun Morgan is very familiar with the practice of the DIFC courts. You may not be, Mr. Obaid, but Mr. Shaun Morgan is very familiar. He has been appearing before courts, in the English courts, rightly or wrongly is another matter. So he knows part 7, part 8 of the how do you file, how do you put your submission. The submission must be put in a few days before. But since he's on his own, we are ready to accept today his submission. We are ready to hear him now. There's no other party. If there's the other party will strongly object putting in the submission at the last minute. But he's the only one to hear. So we will hear you. We will hear him. I suspect, Mr. Obaid, you're asking for another day for hearing. Is that what you are going to do? You want to postpone the case, Mr. Obaid?
No.
No. You are ready to go on today?
Yes.
Okay, go on then. Just go on with the hearing today.
Can
Yes.
I, Chief Justice, can I just
Yes,
ask a question?
Lord Glennie. Yes, please.
Mr. Obaid, the registry gave directions on the 3rd of June of this year. The registry gave directions in relation to your appeal, as well as the appeal by Mr. Morgan. And it says the appellants, and that includes your firm, shall file detailed grounds of appeal by no later than Monday, 17th of June. You didn't do that, did you?
No. We don't have access to the system.
Well, that is, there are many ways of finding a way of getting access if you want to do it. Did you prepare detailed grounds of appeal?
No.
So how is this court on this hearing to know in advance what your arguments are?
If you do not know how to get to the system, Amna or somebody from the courts will advise you how to do it. It's not difficult.
Okay.
I got voices behind. Whose voices are those, please? Okay. Whose voices? I get voices at the back. Mr. Obaid, is that your office?
No.
Apologies, Chief Justice, Justices, that could be mine. I'm trying to move people out of the offices. There's nobody in my vicinity. Nobody's listening to this hearing. My apologies to the Chief Justice and the other
The
justices.
background noise is disturbing, the distraction, causing a lot. Okay. Yes, Mr. Obaid, what do we do now?
Yes, as it's my mistake, I will request for postponement to make my submission.
That's not what we do in the DIFC courts. Mr. Shaun Morgan is very familiar how strict we are about postponements. Once a case is fixed, we go on. Because I'm sitting in London from London now. Mr. Lord Glennie is in Scotland. Judge Shamlan is in Dubai. And getting this arrangement is, we were very strict about giving postponement. And your excuse is that you do not know the system. If you do not know, then you should not be engaged. You should not agree to act for Mr. Shaun Morgan. You should say, Shaun Morgan, I'm sorry, I'm not familiar.
I am not acting for Shaun Morgan, Your Honor.
Yeah, you are. You are.
No.
You are speaking now. You are speaking for him now.
No, Shaun is representing himself, Your Honor.
Okay. Then what are you doing here, Mr. Obaid?
Because the firm as an individual has been a part of the case.
Oh, you are acting for the firm.
Yes.
Oh, you are acting for the firm, not Mr. Shaun Morgan.
Yes.
Okay,
Yes.
then let's go on with the hearing, and you say what you want to say.
Okay.
We'll accept your oral advice, your oral submission.
Okay.
Without writing, we will accept your, so that we can proceed on today. Judges, do we agree that we'll proceed on today? Justice, yeah, we agree we'll go on today, and without written, you can put in your written submission later if you wish, but we are going to go on with the hearing today. So, Mr. Shaun Morgan, shall we start with you?
Yeah, thank you, Chief Justice.
Okay,
Justice Glennie. I will make my submission very short for the justices. As you've said, Chief Justice, it's taken a lot to convene this hearing. I do not wish to seek reinstatement or re-registration with the DIFC courts. I have the utmost respect for the courts and the court's mandatory code of conduct and its procedures. For that matter, the only purpose for this hearing was to seek a more amenable or a more just punishment, which I feel that, with the greatest respect to the esteemed Justice Wayne Martin, he made an extempore judgment without even considering any of the submissions. So I do not wish to seek reinstatement.
Why do you say Mr. Justice Wayne did not consider the submissions?
He, with the greatest respect, and he's obviously an esteemed judicial member of many courts, I believe Australia or the UK. During the hearing, he read off at the end a pre-written judgment without any consideration. So with the greatest respect to the justice, he did not consider in the hearing any of the merits. He simply said, I've had enough, and then deferred to a piece of paper and read line for line the judgment. Now, there was no judgment pre-written. I mean, there was no judgment written during the hearing. He simply read off the judgment which was prepared prior to the hearing. And
Mr. Morgan, can I just be clear about this? When you say he read off the judgment, do you mean he read the whole 34-page reasons, or simply the conclusion?
Simply the conclusions, my lord. He simply read the judgment as per the the registrar. As per the registrar, he read off exactly the points which were listed on the first page of the judgment. No, definitely not the 34-page decision. That was just simply the summary.
Is the seven-point decision in the first, which appears in the first paragraph of the reasons? Is that right?
That is correct, my lord.
Yes, thank you.
And for that matter, I don't wish to go into the background. I have met many of the DIFC court registry staff. I find them to be exemplary and a credit to the justices. Of course, Mr. Obaid bin Tuk Al-Mari referred to the fact that prior to any disciplinary hearing regarding the mandatory code of conduct, there was already information given to a number of the law firms about suspension and about removal, which I found to be unjust, because we weren't even given the opportunity, or myself personally, to try to resolve this. I was under the assumption that Mr. Al-Mari was meeting with the Chief Registrar, Ms. Amna Alawais, and we would not be seeking my reinstatement, but there would be other employees' profit to the DIFC court registration of practitioners to continue. Franklin Morgan Legal Advisory had, I believe, 12 pending cases last year. So it was inherent that a qualified counsel would take over those cases. That was disallowed. But I will not speak to that, because that's the Franklin Morgan Legal Advisory, of which I'm not an employee, I'm not a shareholder, I'm not a director. So I should never have been granted just the initial Part 1 application to begin with. Based on the registration of practitioners guidelines, you must be an employee of the firm where you are seeking a Part 1 registration. I was not, and I have never been a member of the Abu Dhabi firm, Franklin Morgan Legal Advisory. In conclusion, not to waste the justice's time, and I appreciate your time is very valuable, I give the utmost respect to the court. I have had the pleasure to be involved in some hearings, and I find the court to be one of the best courts I've dealt with. And I thank the court for the time, but I will not be seeking reinstatement. I would only respectfully request the justices to look into the punishment given and see it's the most severe punishment allowable under the Mandatory Code of Conduct, Article 33 and 38A, and request that that may be revised. And I thank the justices again, and hope that a decision will be given.
Please remind me, what was the punishment that they imposed upon you?
$15,000 fine and permanent removal from the registration of practitioners.
Permanent. Okay. What are you suggesting?
I'm suggesting that since I'm consenting unequivocally to the removal and I will not seek reinstatement to the list of practitioners, and that the monetary fine, while it's the maximum, should be somewhat reduced. Of course, I defer to the justice's determination on what that should be. And with respect to the public admonishment, I only make the comment, though it seems immaterial at this stage. Not a single client of Franklin Morgan Legal Advisory complained or were upset with the representation. And while this means absolutely nothing, I only mention it for perhaps clarity or for perhaps a balance. This whole action was started by another firm who were representing a very esteemed Emirati lawyer who was subject to some severe civil procedures before the DIFC courts. And rather than answering on the merits of the case before the DIFC courts and or approaching the firm, they sought to engage in a very vile and vitriol exchange of communication, which I could only assume they believed would scare or result in the case being removed. I've never seen such vitriol in my life, but in saying that, that has no bearing on this hearing. It has no bearing on my position. As I said, I quite readily accept and thank the DFSA courts and consent to my removal. I only, again, to repeat myself, respectfully request the justices to consider the punishment.
Okay, you have spoken about the fine of 15,000 USD. You are seeking for a reduction of the fine. What
Yes,
about
Chief
the
Justice.
what about the permanent removal of to be?
My practice is not focused on the DIFC courts. I was only to give assistance to Franklin Morgan Legal Advisory, to Mr. Al-Murray. As I'm not domiciled to continue the cases, I'm happy to be permanently removed. But of course, as I've said, I've enjoyed the DIFC courts. I've been before many of the justices, and I have only extremely positive and exemplary things, not just to say about the justices, but all the support staff that I had the pleasure of meeting. They are a credit to the court.
Yeah, so you are not appealing against the permanent removal and the public admonition, but you are seeking only a reduction of the fine. That's basically what you are.
I am seeking a either a sealing of the order, which is permitted under the final article, I believe 38F of the Mandatory Code of Conduct. I believe a public admonition will not serve the purposes of either the court or myself. And I say that as a very selfish statement, but I see no benefit in a public admonishment, as there has been no client or claimant or defendant, respondent that has complained. This is an action commenced by another law firm seeking my removal and to use that. And I think to weaponize the DIFC courts against myself personally brings no adherent benefit, since I would consent to the permanent removal.
Okay. We taking charge of that.
I
So is that all?
Morgan,
Yeah.
So can I just ask, I suppose, Mr. Morgan, it could be said that public admonishment is necessary sometimes to show the world generally that the court will not put up with certain things. So it's not particular to the case so much as particular to the reputation of the court.
I completely agree with you, my lord, and I have spent some time researching other public notices or admonishments before the DIFC court. This would be somewhat of a, I would not like to say first, but a most severe judgment. But as I've said, I have the utmost respect for the DIFC court. of course, the justices, of which I have the pleasure to be before you today. I can only respectfully request that such a public admonishment, while certainly perceivably pertaining to the credibility of the court, I don't feel that it brings any additional gravity to the punishment or clarity.
I see. Thank you. Can I just clarify one further thing, Chief Justice?
Yes, please.
You've very succinctly set out what your complaint is, what your concern is about the judgment, and particularly the fine of $15,000. Can I take it from that you don't challenge the fact findings made by the judge?
I challenge the veracity of the fact finding, as there was no documentation submitted from an official source. And I think I had alluded to in the previous skeleton arguments before the first hearing, before the esteemed Justice Wayne Martin, that sometimes in cases we now fall into a mongering of internet innuendos, which can not always be based in fact. So with regard to the fact finding from the esteemed justice, yes, I have issue with that. And I was hoping, when I have written to the registry about alternative dispute resolution, was to meet with the registrar, if given the opportunity, or with Chief Justice, if I was given such an audience, and give a detailed explanation with official documents. But I was never given such an opportunity. And that's why I find it to be disappointing. I was always seeking alternative dispute resolution under RDC 27, and I've mentioned that continually through all the submissions.
I think my question was more for the purpose of this appeal and for the relief you seek from this court, which I think is focused on the 15,000. You may not like the judgment and the fact findings, but you don't seek to persuade this court to set them aside.
I do not, my lord. I see no benefit in having it set aside at this stage. The point of the hearing was to, thank you, my lord.
Yeah, thank you very much. I understand.
So you, in short, you accept the finding of facts by Judge Martin. Is that what you're saying?
No, I just do not wish to have them set aside. The point of the appeal was to seek a reduction of the punishment given, Chief Justice.
Okay.
Sorry.
Understood. Okay, understood. So that's finished with you, Mr. Shaun Morgan. Now I turn to Mr. Obaid about your firm. Yes, you're representing the firm.
Yes, and the reason of our appeal also to reduce the fine, which has been issued against the firm. The firm are tried and submit many candidates to be registered.
How much fine was imposed against your firm? I forgot already.
50,000.
50.
Yes.
Okay. Yes. Another one? Yeah, go on. Yes, Mr. Obaid, please go on.
And it's immediately removal of the firm without allowing us to submit any candidate or any other lawyers was not permitted. Now we understand Shaun Morgan was having some questions and some requirement additionally by the registrar. We submit many other candidates which is not being allowed to register under the firm. We submit 2 Emirati candidates. We submit 1 candidate from Turkey, and we did not being allowed to register anybody under the firm. The firm is immediately, once the suspension of Shaun Morgan issued, the firm immediately being removed. And after that, when we was trying to meet the chief of the registrar to understand what the requirement and what the comments, and the same day, after I finished the call with the Amin Al-Uwais, we got the notice about this case. What we are seeking to reinstate the firm, allowing us 30 days to comply and provide other counsel to be registered under the DIFC court. And the reduction of...
Let's look into it. Whether, I don't know. Yes. I'm not sure. Are you saying that your firm cannot be registered for whatever reasons in the future? No? That's why even if you bring a qualified lawyer?
Yes. We provide many candidates and we will not be entertained to submit any candidate to the registrar. And we fail to understand the reason behind that.
Look. That is not part of the... It's not part of the appeal, is it? Is it? Judge Lord Glennie? Lord Glennie, you want to say something about that? Your mic is off. Your microphone is off.
Sorry about that.
Okay.
You can hear me now?
Yeah.
Yes. The difficulty is we don't have any grounds of appeal from the second second appellants. And I'm not sure the way that the judge, Justice Martin, approached the matter was that it was necessary in the interests of justice to punish the second appellants, or they're simply passing on without proper checks the registration relating to Mr. Morgan. And I think we find that on paragraph 120 of the judgment of the reasons. The FMLA assisted Mr. Morgan in the perpetration of his attempts to deceive the court in circumstances in which the firm must have been aware that there's a serious question in relation to Mr. Morgan's entitlement to be registered. The firm reiterated his false assertions dogmatically, and so on. And it says that conduct falls so far beyond the standards of conduct expected of a reputable law firm that it must be concluded the firm is not fit and proper to remain on the register.
Shall we... What's crossing my mind now is, since Mr. Obaid, shall we give Mr. Obaid, say, 2 weeks for him to put in a written submission? Because we cannot fairly judge his case without knowing the full background of the case. So I was wondering that we should give him 2 weeks to put in his written submission, and then we'll consider and make our decision. What do you think, Judge Shamlan? Judge Glennie?
I have no any objection with that.
Yes,
I have no objection to that, but that is without a further hearing, just simply...
No more hearing. Because it's a one-party hearing, so we don't have to hear the other party. We'll just give an opportunity to Mr. Obaid, whether you want to put in yourself, whether you want to engage your counsel, familiar with the DIFC courts to do that, is up to you. We'll give you to... What's the date today? Today is Monday. So by Monday, what's the date? Monday. Because I find it difficult to make a decision without fully knowing the background, and I want to make a fair decision. I don't want to make a wrong decision.
By 5th of August, 2 weeks? 5th of August?
Yes, 3rd of August, Friday. No, 2nd of August. By 4 p.m., 2nd of August. No, 4 p.m. 4 p.m., 2nd of August. We're giving an opportunity to you, Mr. Obaid, to put in the written submission, but you must do that by the 4 p.m. on the 2nd of August. Get that clearly? You understand?
Yes.
Whether you want to put in your submission personally, yourself, or through a counsel, I would strongly advise you get somebody who is familiar with the DIFC courts system, and then put in, and then we'll consider and make a proper decision. I feel a bit hesitant. I want to do justice here. whatever you want to say, you put in that piece, your submission.
I will do.
And
Thank you.
but not too long, please. Not too long. So, as for you, Mr. Morgan, we'll come back with a decision about about you together when we have heard what Mr. Obaid has to say in his submission. We will come with a decision in respect of you as well.
Thank you, Chief Justice. Thank you, my lord. Thank you, Justice Shamlan.
Is that agreeable, Mr. Justice Shamlan and Lord Glennie?
Yes, that's fine.
Of course.
Yeah.
I think that's fair. That's fair to parties. Then we'll come back. And also, there's no urgency in this decision. But presently, Mr. Morgan, the order by both of you, the orders made by Mr. Wayne Martin stands as of today, until we make our decision to uphold or to revise that decision or the orders made by Mr. Justice Wayne Martin.
Understood, Chief Justice.
Okay. Can we go back to the other channel, judges, to the discussion link?
Yes,
Then
I'll try.
for that, I will then adjourn this hearing. And we won't have any more hearing in person. We will read what submission you have to put in, or your counsel has to put in, Mr. Obaid, and we'll make a decision. We'll give you a decision when we are ready to do so. Okay?
Thank you.
Thank you
Thank you,
very
Chief
much.
Justice. My lord, Chief Shamlan. Thank you.
Thank you very much.